Well, continuing coverage now with expert legal analyst.
Kenneth Lawson is with the University of Hawaii Law School and joins us now. So what is the main takeaway for your students in this case?
Well, it's a hung jury. I think it's a good case to look at when it comes to all kind of areas of law. But, you know, the report that was just done about the lesser included offense of manslaughter, you know, I find it inconsistent for the prosecution to bring in evidence of alcohol and argue it's a major factor in why Dee Dee shot this young man, and then say there's no evidence of manslaughter. You know, I think it's inconsistent for the court to say that Dee Dee says it was self-defense. It doesn't matter what he says. What matters is whether or not the jury believes him. So that's still not an excuse not to give the lesser included offense of manslaughter.
Do you think that was really an unnecessary gamble by just giving him?
I think that's why the jury was hung. I think that some jurors were saying, you know what, we just can't allow this to happen. We can't, you know, even though he may not be guilty of murder, we believe he's guilty of manslaughter or something, and we're not going to find him not guilty by agreeing that he's not guilty of second-degree murder.
Now both sides get it to essentially reset. What do you think we can expect to be different the next time around, and do you think they'll include that manslaughter charge in the second trial?
Based on what the prosecutor just said in that last interview, I don't think that they will, but who knows? I hope they change their mind. If they don't change their mind, then don't argue alcohol was a factor in the shooting, you know? But it's harder on a defense when your client has testified, right? And then there's a mistrial. And now you got to go to trial again. Now the prosecution knows exactly what your client's going to say if he takes the stand, how he's going to say it, how he comes across, etc. Prior to that, the defendant has no right to get on the stand, so the prosecution really doesn't know how you're going to come across and exactly what you're going to say was your reasons for shooting this person in self-defense. So at this point, the defense may be at a disadvantage, but the prosecutor just said she had trouble getting her witnesses at court, right? Which means that the second time around, it may be even harder, because some witnesses will say, you know what, I'm tired of this, I don't want to be sitting down there, and it's hard to find them. So it's going to be interesting to see how it plays out.
Well, thank you so much, Kenneth Lawson from the UH Law School. Thank you for joining us with the insight from the many years you've had in law. Well,